Welcome to our deep dive into a series of historic shifts at the highest court in the land. Today we are looking at how a few specific rulings are fundamentally changing the office of the presidency and the way our government functions. From new rules on immunity to the power to fire independent experts, the lines are being redrawn. Let's get started. Let's play this clip.
The Supreme Court has refused to allow the Trump administration to deploy National Guard troops in the Chicago area. The court declined the administration's push to lift a ruling blocking the deployment. 3 conservative justices dissented. A 4th said he would have issued a narrower decision. The outcome is a rare Supreme Court setback for President Donald Trump. He has won repeated victories in emergency appeals since he took office again in January. The Trump administration has argued that troops are needed.
For nearly 90 years, there was a fundamental wall in the city of Washington. It was a wall built on a very simple idea. That idea was that some parts of the government are so important and so based on expert knowledge that they need to be independent of the White House. This meant that a president could not simply fire the leaders of these agencies just because he disagreed with them or because he wanted to install a political ally. These agencies, like the National Labor Relations Board and the Merit Systems Protection Board, were designed to be bipartisan and steady. They were meant to protect the public good over the long term rather than serve the political whims of whoever happened to be sitting in the Oval Office at the moment. But on May 22, 2025, the Supreme Court of the United States issued an order that began to pull those bricks out of that 90-year-old wall. In a case called Trump versus Wilcox, the Supreme Court granted an emergency request from the administration to stay lower court orders. Those lower court orders had originally stopped the president from firing members of the National Labor Relations Board and the Merit Systems Protection Board. By law, the president is actually prohibited from removing these specific officers unless there is a very good cause, such as neglect of duty or legal wrongdoing. In these cases, the administration admitted that no such cause was given. Essentially, the president fired them because he believed he had the power to do so, regardless of what the statute said. The Supreme Court, in its brief order, said the government was likely to show that these boards exercise considerable executive power. Because the Constitution puts executive power in the hands of the president, the court reasoned that he should be able to remove those who exercise that power on his behalf. This might sound like a technical debate about government hiring, but the consequences are massive. Justice Elena Kagan, writing in a sharp dissent, joined by 2 other justices, argued that this decision allows the president to take the law into his own hands. She pointed out that a precedent from 1935, known as Humphrey's Executor, has protected the independence of these agencies for almost a century. This precedent is what allows agencies like the Federal Trade Commission and even the Federal Reserve to function without being completely controlled by the White House. By allowing these firings to move forward on the emergency docket, Justice Kagan argued that the court was essentially blessing the president's decision to upend nearly 100 years of history without a full trial or even a full explanation. The court's majority did say they were not yet making a final decision on whether these agencies fall into a special category of independence. However, they also stated that the government faces a greater risk of harm if a removed officer stays in their job than the officer faces if they are wrongfully fired. This shift suggests that the court is moving toward a much more powerful version of the presidency, one where the president has a unitary or all-encompassing control over every corner of the federal government. Critics of this move argue that it ignores the intent of Congress. When Congress created these boards, they specifically wanted them to be balanced along partisan lines so that experts, not politicians, would make the big decisions. Now, that balance is in question. To understand why this move against independent agencies is so significant, we have to look back at the foundation laid a year earlier. In July 2024, the Supreme Court issued what many call a landmark decision in the case of Trump versus United States. For the first time in American history, the court was asked to decide if a former president has immunity from being prosecuted for crimes committed while in office. The court's answer was a resounding yes, though it divided that immunity into 3 different levels. The first level is absolute immunity. The court ruled that when a president is using his core or exclusive constitutional powers, he can never be prosecuted for those actions. This includes things like the power to grant pardons, the power to recognize foreign nations, and notably the power to manage the investigation and prosecution of crimes. Because these powers belong solely to the president, The court said that neither Congress nor the courts can ever look into those actions to see if a crime was committed. The second level is presumptive immunity. This applies to all other official acts the president takes. These are actions that fall within what the court called the outer perimeter of his official duties. If an action is considered an official act, the law assumes the president is immune from prosecution. A prosecutor would have to prove that bringing a case would not interfere with the authority or functions of the executive branch. A task the court admitted would be difficult. The majority even said that most of a president's public statements, including the use of the bully pulpit to talk to the American people, would likely count as official acts. The third and final level is for unofficial acts. For these personal or private actions, the court said a president has no immunity at all. But there is a catch. The court also ruled that even when a president is being prosecuted for an unofficial act, the jury is not allowed to see any evidence that involves an official act. For example, if a prosecutor was trying to show that a president took a bribe in exchange for an official act, they could show the bribe was taken, but they might not be allowed to introduce private records or testimony from advisors about the official act itself. The consequences of this immunity ruling were felt immediately in the various cases against Donald Trump. The Supreme Court specifically determined that the former president is absolutely immune for his discussions with Department of Justice officials regarding election investigations. This means that even if a president pressured the DOJ to conduct sham investigations, those actions are considered a core power and cannot be prosecuted. The court also found that he is at least presumptively immune for pressuring the vice president to change the certification of the 2020 election results. The court reasoned that whenever a president and vice president discuss their official duties, it is official conduct. Justice Sonia Sotomayor, in a very strong dissent, argued that this ruling fundamentally changes the relationship between the president and the people. She wrote that in every use of official power, the president is now essentially a king who is above the law. She pointed out that under this new rule, a president could theoretically order the military to assassinate a political rival or organize a military coup and still claim immunity because commanding the military is a core power. The majority of the court dismissed these scenarios as fear-mongering, but many legal experts and historians have expressed deep concern. They argue that the founders of this country specifically hated the idea of a monarchy and intended for the president to be a citizen who could be held accountable for breaking the law. As we move into 2025 and 2026, we are seeing how these rulings on power and immunity are playing out in real-time policy battles. In June 2025, the Supreme Court delivered another monumental victory for the administration by changing the way lower courts work. For a long time, individual federal judges had the power to issue nationwide injunctions. This meant that if a judge in one state found a federal policy to be illegal or unconstitutional, they could stop that policy from being enforced across the entire country. The administration had long complained that this process allowed a single judge to block their entire agenda. In a split decision, the Supreme Court ruled that individual judges can no longer issue these nationwide stops. President Trump praised the ruling, saying it was a victory for the separation of powers and the rule of law. He immediately announced that he would use this new legal landscape to push forward with policies that had previously been blocked, such as his efforts to restrict birthright citizenship. Vice President J.D. Vance also cheered the decision, calling the old system a ridiculous process that was used to sabotage executive action. However, many others are worried about what this means for people's rights. Krishomara Vignaraja, a leader at the group Global Refuge, warned that this ruling could create a dangerous patchwork of rights across the country. For example, if birthright citizenship is enforced in one judicial district but not another, a child's citizenship could depend entirely on where they were born. Legal experts warn that without nationwide injunctions, there will be less uniformity in federal law, which could lead to chaos and inequality. While the administration has won many battles at the Supreme Court, the justices have not given them everything they want. We saw this clearly in late 2025 in a case involving the immigration court system. The administration has been trying to completely overhaul how immigration judges do their jobs. Their goal was to make deportations happen much faster. To do this, they implemented new rules that pressured judges to decide cases more quickly and limited their ability to delay or close cases. They also made it easier to discipline or fire judges who didn't meet certain quotas. Legal groups sued, arguing that these changes were a violation of due process and judicial independence. They argued that if a judge is being told they must finish a certain number of cases every month or lose their job, they won't have time to properly listen to an asylum seeker's story or look at the evidence. Lower courts agreed and blocked the administration's new rules. The administration then went to the Supreme Court, asking for an emergency order to let the policies go into effect immediately while the appeals process continued. Surprisingly, on December 19, 2025, the Supreme Court said no. They refused to lift the blocks on the immigration judge policies. Even though this is a very conservative court that has been friendly to the president's goals, they seem to be drawing a line when it comes to the fairness of court proceedings. This was a major setback for the president's mass deportation agenda. If immigration judges aren't under pressure to rush through cases, the process of deporting people remains slower. Reports indicate the president was furious about this decision because he has promised the largest mass deportation in history and needs the court system to cooperate to make it happen. This brings us to another high-stakes standoff that happened just days later, right before Christmas 2025. This case was about the National Guard. The president had announced a plan to deploy 10,000 National Guard troops into cities like Chicago, Los Angeles, and Portland. He said these troops were needed to fight crime and help federal officers enforce immigration laws. The big catch was that he wanted to do this without the permission of the state governors. The state of Illinois and the city of Chicago went to court to stop him. They argued that under the Constitution and federal law, the president cannot just send military forces into a state to enforce domestic laws without the governor's approval. The administration pointed to an old federal law that allows the president to call up the National Guard when he is unable to execute the laws of the United States with regular forces. The Supreme Court, in an unsigned 3-page order, blocked the president's plan. The court's majority looked at the history of the law and decided that the term regular forces likely refers to the actual United States military, not just civilian police officers. This means that before the president can call in the National Guard, he has to show that he has the legal authority to use the regular military first and that those forces are unable to do the job. The court said the government had failed to identify any such authority. This ruling was a rare and significant check on executive power. Chief Justice John Roberts and Justice Brett Kavanaugh both indicated that the president cannot simply bypass the states and use the military for domestic law enforcement whenever he wants. Justice Kavanaugh, in his own opinion, noted that the president hadn't even made the formal determination that the regular military was unable to handle the situation. However, 3 conservative justices, Alito, Thomas, and Gorsuch, dissented. Justice Alito wrote that the protection of federal officers from attacks should be the priority and that the court shouldn't let technicalities get in the way of that. He criticized the majority for changing standard practice and reaching out to decide issues that weren't fully briefed. The president's reaction to this National Guard loss was described as a complete meltdown. In a series of social media posts, he reportedly called the justices traitors and treasonous, and even called for their impeachment. This reaction highlights a growing tension between the White House and the judiciary. Even though the president appointed 3 of the justices on the court, they are not always voting the way he wants them to. For someone who expects total loyalty, this has been incredibly frustrating. To put all of this into perspective, we have to see the larger pattern. Organizations like Protect Democracy describe what is happening as a form of legalistic noncompliance. This is a tactic where an administration uses legal language and procedures to push the boundaries of their power, effectively trying to see how much they can get away with before a court stops them. In the first 6 months of the second term alone, courts in at least 12 different cases found that the administration had violated court orders. This authoritarian playbook, as some call it, involves several steps. First, the administration dismisses the authority of lower courts. Then, they might cite administrative errors to explain why they aren't following an order. In some cases, whistleblowers have alleged that the administration intentionally defied the courts just to send a signal that they don't intend to be held accountable. The consequences of this defiance are not just abstract legal theories. They have real-world impacts on people's lives. In cases where the administration has pushed the limits or ignored court orders, people have been deported without their fair day in court. Funds that Congress set aside have been withheld, and federal employees have been fired without cause. Government lawyers who refuse to go along with these strategies have reportedly been punished or have resigned in protest. Despite all of these aggressive moves, the system of checks and balances is still standing, for now. District court judges and lawyers are still using the tools they have to enforce the law and hold officials accountable. Public opinion polls also showed that a vast majority of Americans, including many who support the president, believe that he must follow the rulings of the courts. One poll found that 81% of adults believe that if a federal court rules that an action is illegal, the administration must follow that ruling. Another poll showed that 83% of Americans believe the president must honor Supreme Court rulings, even if they are divisive. But the legal ground is shifting. The 2024 immunity ruling has created a shield that makes it much harder to hold a president personally accountable for his actions. If a president knows he cannot be prosecuted for official acts, he has less incentive to stay within the lines. He can try aggressive new policies, and even if a court eventually blocks them, he faces no personal consequences. He simply stops doing that one thing and moves on to the next aggressive move. This has led to a situation where the court is salami slicing away the limits on executive power, one piece at a time. Every time the court expands immunity or limits the power of lower courts, the presidency becomes more powerful and less transparent. Justice Ketanji Brown Jackson warned in her immunity dissent that this ruling makes the judiciary a gatekeeper of accountability and weakens the power of Congress. She wrote that for the first time in history, the most powerful official in our country can, in some situations, become a law unto himself. As we look toward the 2026 midterm elections, these legal battles are becoming a major political issue. Democrats are arguing that the president is acting in a lawless and cruel manner, while Republicans are arguing that the president is simply trying to do the job the people elected him to do, but is being sabotaged by activist judges. Both sides are using the recent Supreme Court rulings to fuel their arguments. The No Kings Act, introduced by Senate Democrats, is one attempt to reverse the immunity ruling and declare that only Congress can grant immunity. There are also proposals for constitutional amendments to ensure that no one is above the law. But these efforts face an uphill battle in a deeply divided Congress. The independence of our government agencies is also still in the crosshairs. If the Supreme Court ultimately rules in the Wilcox case that the president can fire the leaders of independent boards without cause, it would be the end of the 1935 Humphreys executor precedent. This could open the door for the president to take direct control over the Federal Reserve, the Federal Trade Commission, and the Federal Communications Commission. Instead of having experts set interest rates or enforce trade rules, those decisions could be made by political appointees in the White House. Justice Kagan summarized the stakes quite clearly. She argued that the whole point of independent agencies is to have specialists balanced along partisan lines who make sound judgments because they are not fully controlled by the White House. She stated that the majority's willingness to allow these firings reveals a desire to create the most subservient administration in American history. In the end, what we are seeing is a fundamental test of the American system. The Constitution was designed to distribute power so that no one person or branch would have too much authority. It was built on the idea that states have their own sovereignty and that the president must operate within the law. For nearly 250 years, that system has relied on a delicate balance between the president, the Congress, and the courts. Today, that balance is being pushed to its limits. The Supreme Court is in the middle of a struggle between an administration that wants to act boldly and unhesitatingly, and a legal framework that was designed to provide caution and due process. Sometimes the court provides the president with a sweeping amount of protection, as they did in the immunity case. Other times they slap him down, as they did with the National Guard and the immigration judges. This creates a volatile environment where no one is quite sure where the lines are anymore. The administration continues to push, the courts continue to react, and the public is left watching a historic transformation of the presidency. Whether the system of checks and balances holds, or whether we move toward a system where the president has unlimited authority, is the question that will define this era of American history. The battles over who can be fired, who can be prosecuted, and who can send troops into our cities are not just about legal technicalities. They are about the core of our democracy. As former federal judge Michael Luttig put it, the rule of law is the heart and soul of this country. He warned that the recent moves to grant broad immunity and limit accountability have cut that heart and soul out of America. Whether you see these changes as a monumental victory for a strong leader or a dangerous precedent that threatens our freedoms, one thing is certain: the rules of American power have been rewritten, and we are only just beginning to see the consequences. The path forward is uncertain, and the stakes for the future of our government could not be higher. To help us understand what this looks like in practice, think of our government like a massive ship. For nearly a century, that ship has had multiple captains and a system of heavy anchors, the independent agencies, the courts, and the Congress, all designed to keep it from moving too fast or veering off course. These recent Supreme Court rulings are like cutting those anchor chains one by one. The ship is moving faster now, and the person at the wheel has more control than ever before. But without those anchors, it's much harder to stop or change direction if the ship starts heading toward the rocks. We are now in uncharted waters, and the safety of everyone on board depends on whether those final remaining checks can still hold the line. Thank you for joining us for this deep dive. This is a story that is still being written in courtrooms and in the halls of power every day. We will be here to track every development as the balance of power continues to shift. Don't forget to like, subscribe, and hit that notification bell so you never miss a deep dive into the stories that shape our world. We'll see you in the next one.